46, equal portfolio recovery. One second, Ken. Okay, go ahead. Yeah, you want rebuttal time, Ken?
Yes, I do, Your Honor. If it might please the Court, I would like 1 minute of rebuttal time.
1 minute? You have it. Go ahead.
And also, if I could, maybe 3 minutes near the end of what I'm saying so that I can actually make certain points that I do want to cover, especially with the amicus brief that was just filed.
We'll see how that's
After your hot bench, I'm blown away by what I'm seeing here.
Go ahead. Get started.
First, some of the statements made in this are not accurate. They're not consistent with the brief. I was told by Clerk Costello, don't worry about it. You guys read the brief, so I'll leave that.
We do. Go ahead.
Great. First, I would like to thank the Court of Appeals for hearing this case. I am grateful, and I will be more grateful if you write a decision on the questions presented to you that is more lawful, noble, and just than the decisions from the lower courts. Perhaps we just need a wise Latina on the bench. The most important point I have to share with the Court of Appeals is to emphasize that this is an appeal involving 4 claims of error. 4 claims that go to the fundamentals of civil procedure and the codes of professional responsibility and judicial conduct in the state of New York. Although courts often, I would say too often, do not decide all questions of error presented to them, often to manipulate an outcome of a court's choosing, I would urge the Court of Appeals not to do so in this case. As the unanimous Court of Appeals recognized in Cook v. Village of Mohawk, one of the principal functions of an appellate court is to make law as certain as possible by reducing to a minimum the errors of practice which may affect a class of cases or the general rules of evidence. I would suggest this principle is especially relevant to the role of the Court of Appeals in New York State jurisprudence. Although I had asked a number of organizations to submit amici briefs in this case, I made no specific request of them as to what to write. The fact that each of the 4 questions has been addressed by at least one of the briefs is indicative of the level of concern regarding all of the appellant's questions before the Court. The first question presented to the Court was regarding Portfolio Recovery Associates' lack of standing in this case. The appellant's brief and the amici briefs of New York City Bar Association, Department of Consumer Affairs, and AARP Foundation Litigation et al. Address this question. The Court can read the briefs. Let me just emphasize the importance of the principle of standing to defendants, not just in consumer collection cases, of which there are hundreds of thousands just in the city of New York, let alone the rest of the state, but also in mortgage foreclosure cases, of which I am certain that there are and will be many in the state. The trial court's unique interpretation of existing statutes and case law, given the plaintiff's lack of an assignment in this case, is disturbing, to say the least, because it allows for and encourages fraudulent collections and foreclosures. The second question presented to the Court was regarding the expiration of the statute of limitations before the plaintiff commenced suit. The appellant's brief and all amici briefs submitted addressed this question. Of course, again, the Court can read the brief submitted. One extremely important point of clarification. Regardless of the application of CPLR 202 and the Delaware 3-year statute of limitations, New York's 6-year statute of limitations had also expired before the plaintiff commenced suit. Please see pages 21 through 26 of the appellant's brief and relevant citations to the record.
Well, when's the last time? Sorry.
Mr. King, does your papers tell us when you moved from Connecticut to New York State?
They do in the case file. Mr. Spolzino made a reference to the fact that, for example, a website page is not in the record. That's all in the case file, which is part of the record under 500.14 of your own rules. And I have spoken to Mr. Costello this morning, or earlier today, and he mentioned to me that you have already requested that. That is there.
When we find it, when will we find out you moved from Connecticut?
You will find it because it's in an affidavit.
What's the date?
Oh, October 1st, maybe like the 30th I moved, and October 1st was the rental date of 1999.
And when did this cause of action accrue? I mean, Discovery says they charged off the debt on August 31st of 99.
They charged it off on 99. They had a payback bonus award, I believe, April 19th. As the record shows, when you look at the statements.
And you stopped paying it in December?
I believe so, yes. And then January was the last invoice, I think, something like that, yeah. So early January is the last payment. That's the last date.
Any way you slice it, you were a Connecticut resident when the claim arose.
That is correct.
So the claim has to have arisen either in Connecticut or wherever Discovery's residence is, which might be Delaware, correct?
It might be Delaware, but the record in the case file will indicate that website There's information not in the record, which, of course, means we'll go back to the trial level, which I can introduce about that, but yes. Okay. So with respect to this issue here, although there are very different motivations, it is noteworthy that Mr. Murtha's respondent's brief, Mr. Spolzino's respondent's brief, and even Mr. Hutter's amicus brief all make the claim, Mr. Hutter without substantiation, that Portfolio Recovery Associates' claim is timely under New York's 6-year statute of limitations. I spent a lot of time in one of my reply briefs going point by point to get the dates right so that you know that that's actually false. The third question presented to the Court was regarding the inapplicability of summary judgment with an outstanding factual dispute as to the amount the defendant owed. The appellant and AARP Foundation litigation addressed this question in their briefs. As the Court of Appeals and lower appellate division courts from all departments have stated repeatedly, summary judgment is not an available remedy in cases where there is a factual dispute. As noted in the appellant's brief, the New York State constitutionality of CPLR 3212 was questioned after the statute was passed.
So what do you want us to do? You want us to send this back to determine a factual dispute as to their residency?
No, Your Honor. I believe the record shows that based on a motion for re-argument filed by Attorney Herrick, who included that as Exhibit 4, that website, which is identifies the Discover Bank as being headquartered. I mentioned also, that was one of the...
I thought you said there was a question as to the residency of the plaintiff.
The plaintiff, Judge Smith, said that, question is it in the record as Delaware.
Sir, let me just interrupt you for a second. You have about 2.5 minutes left.
Okay. Well, then...
finish answering the question and then make whatever other points you'd like to make.
Your Honor?
Well, I asked you what do you want us to do. Do you want us to
I'd
send
like
it back to the trial court to resolve some of these issues?
I would like you to actually dismiss the case if it's possible pursuant to lack of statute of limitations, because I think the 6-year statute applies. I think arguably the 30-year does too, if you want to follow the logic of global finance.
If we don't know where Discover Bank was, if we don't know where they resided.
They reside, according to that website page, which is in part of the motion for re-argument, which is after the notice of appeal, filed motion for re-argument with Attorney Stephen Herrick writing the argument, Exhibit 4. He found that on their website.
But there's a Delaware address on the bill, isn't there?
There is, yes. But
So,
Mr. Spolzino has argued that's not sufficient. So I'm just saying in terms of headquarters.
I assume you would say it is, or at least it's up to him.
I'm saying you guys, Judge Katie did a phenomenal job in global finance. Read the decision. And many of you actually were part of that decision. Fourth question was the issue of what constitutes a minimum standard for New York State court decisions to be legally sufficient. The appellant's brief and AARP Foundation amicus brief addressed this question. Appellant only found the Court of Appeals cases establishing a standard of substantial evidence for governmental agency evidential determinations attacked for being arbitrary in Article 78 proceedings. The Court of Appeals and appellate division courts appear to be silent regarding this, according to judicial decisions. The AARP addressed issues of professional conduct and independent judgment from lawyers that are being required of debt collection firms. We're on virgin territory here, and I'd really love it if you would make decisions can be just like one sentence, but if you would address this point also, as Senator Daniel Patrick Moynihan said, you're entitled to your own set of facts, you're not entitled to your own opinions. And then lastly, in terms of some of Judge Spolzino's arguments, there are certain factual misstatements here. First is that the plaintiffs have not alleged anything improper or abusive in practice. That has been throughout the proceeding, including the answer and also in my motion for summary judgment opposition. He also claims that I had not talked about 202,
Counsel,
which I did as an answer, and then there was
take about
20
seconds.
Yeah, right.
And
The third issue here was just if you let me find my the issue was 500.14, which we discussed, the fact that that website is in fact in the record.
I know the red light is didn't Professor Hutter agree that this case is time barred?
Professor Hutter, when I spoke to him, because if this case were just about 202, you'd be listening to Professor Hutter here. It's more than that. He refused to argue that area. That there are people in the bar that want to really use 202 as a way to address it for a 3-year statute of limitations. we have to remember, Mr. Hutter's not a professor in this case. He has to be a practicing attorney. There are other matters here, too, and in particular, a 6-year statute of limitations
Okay,
applies,
Ken,
which,
you'll have
frankly,
your 1 minute
I
rebuttal.
understand. Thank you very much.
Thank you.
Good afternoon, Your Honor.
Counsel.
There are 3 issues in this case. The first is whether Mr. King owes the money that's at issue here, and there's no dispute that he does. The only thing he ever questioned was a few incidentals.
When do you say the claim accrued?
That's a good question, Your Honor. I think this Court has never addressed when a claim accrues in a credit card debt.
I mean, my
context.
problem with this case, and it's the same thing Mr. King just said, I don't see how you get it accrued in less than 6 years. And I don't see how you can, any way you slice this, how you can wait more than 6 years to bring the case.
Well, if this is an account, an open account, and the only thing analogous that I could find was a merchant's account that the Court of Appeals many, many years ago treated as an open account. This account was open until the end of August, which makes this action, which was
Well,
August of 99?
August of 99.
He cut the card in half and mailed it in January of that year, right?
He did.
So as far as he's concerned, it's closed, and then the only activity was, I think, some bonus thing for...
That's right.
But that's allowing the creditor then to decide when the account closes. Is that all right?
Except, Your Honor, if all that this were resting on were the interest charges, I'd agree with you. But this is a credit that Mr. King has accepted as part of his account. So if the account is open, it was open for that purpose the middle of April, which satisfies the 6-year statute of limitations.
So when did the lawsuit begin?
The lawsuit began the first week in April. That credit came in sometime April 18th.
In March of 99, if you had sued him. If you had sued him in March of 99, your lawsuit would not have been premature, would it?
Wouldn't have been premature. March of 99? No, it wouldn't have
Before the
been
credit.
premature.
Before the credit, after he ripped up the card.
That's correct. It wouldn't have been premature. I think the question, though, Your Honor.
Well, can you anytime, you're saying anytime you cut down the debt or give him a credit, you start the statute running again?
Well, I think this was a credit that was part of the ongoing relationship between the parties. This wasn't simply the creditor saying, okay, we're going to give him a credit now so we can restart the statute of limitations. This was part of the ongoing relationship.
Still expected payment, correct? I mean, he had ripped up his card, he wasn't using it anymore.
Right.
But there was still an $8,000 whatever balance on, you still expected to be receiving payments, right? He was 30 days late, 60 days late, 90 days late, 120. And finally, in August, it was charged off. Okay, we're not going to get payment from him, so we'll give it to a collection agency. That's what happened.
That's correct. And that's the nature of a credit card relationship. It's different. It's much more like this merchant account situation from the 19th century, which continues to be viable until such time as the account is no longer open. And that's why I would submit that the the action was timely.
So you say the 6 years or the 3, well, you say it's 6 years, and you say the 6 didn't start running as long as the account was open?
That's correct.
And can you keep it open as long as you like?
Well, I think there comes a point, Your Honor, where it becomes unreasonable to keep it open.
Could you could have kept it up in a year or two?
Well, I would be willing to live with 6 months. You could keep it up. At such time as you're reasonably expecting payment and keeping the account open to that extent. But here, beyond that.
What's unfair about making a creditor sue within 6 years after the debtor has said, I'm not paying you?
Nothing's unfair about it. The question is, when did the statute of limitations accrue under this particular statute that applies to open accounts?
And if we decide it accrued any time before April of 99, then all the other issues are moot, right?
Correct.
Is there any kind of commercial practice or practice that credit card companies follow in terms of how long you keep an account open?
I'm not familiar with that, Your Honor. It's not on this record anywhere, and I'm not familiar with what that practice would be. But in this case, you have a situation where the account was still open for the purpose of a credit at least until April, and we're only talking about August when they finally
It went
decided.
to portfolio when?
I'm sorry, Your Honor?
The account was transferred to portfolio when?
I can get that date for you. I believe that's reflected on the assignment.
The reason I'm asking is how long did portfolio wait before it commenced the action?
I can't.
I know
believe it was
Mr. King
2004. I believe it was 2004 was the assignment. Although that's
And they waited
from the
how long
limited-
before they commenced the action?
A year. We started in 2005.
They said they spent a year making phone calls and then they sued him?
I assume so, yes. That's not reflected again in the record, but I assume
Attempts at collection.
that's right. That's right.
Mr. King makes the point that you have no standing because there's no assignment in the file, and that seems to be true.
Well, there's a document in the record that was submitted on the motion for summary judgment that states that there was an assignment of this particular case.
Is that the best evidence of it?
Well, best evidence in the
It's not the
legal
agreement.
sense.
It's not
definitely not the agreement.
Right, but why is that accepted? Was there a finding of that the real document was not available?
There was not, Your Honor. But I think in the context of this kind of case, the document that was submitted here is essentially sufficient.
Why in this kind of case?
Well, because it's an institutional case. This is not a case of two individuals arguing about an assignment. This is a document that was by a person at Discover who identified a particular assignment and who said that the assignment was to a particular entity.
What was strange about that, if it's the same document you're talking about, is this person was from Cleveland. PRA is in Virginia. Discover, I guess, is in Delaware. And she described herself as a team leader. She didn't say she was an officer or director or financial officer of any kind. And it was hard to determine what a team leader was and what gave a team leader authority to say, I don't have it on me, but I swear to God this thing was assigned.
You're right. And I agree with you, Your Honor, that the niceties of the business records exception were not satisfied here. No question about that.
So would you be adverse to this going back on a question of fact?
Well, that at best it creates a question.
To allow you to put in your proof?
At best it creates a question of fact, Your Honor, that would have to be addressed. The motion for summary judgment.
Well, were what he says are deficiencies in your proof pointed out at the time?
But they were not, and that's the point I was going to make.
You say it's just unpreserved.
There was no dispute, really. Mr. King has consistently said I wouldn't talk to them until they provided me with proof and so forth. But these particular deficiencies in the document were never raised before.
But wouldn't you be expected to comply with the niceties, as you say, as a business entity?
Well, yes, Your Honor, but the essential purpose of the document was established, I would argue. The essential purpose of establishing that there was, of producing some evidence that there was a true assignment here was satisfied. It was never questioned in the Supreme Court. And so there's no basis, I would submit, for questioning it here. The real issue here is, as I see it, Mr. King owes the money. There may be some question about the New York statute, although I think the New York statute has been satisfied. I would submit that I can address the Delaware statute if you like, but I've thoroughly addressed it in the brief. And if there are questions, I'll be happy to answer them.
Why doesn't 202 require us to use whatever the shorter of the two is, whether it's Delaware or Connecticut or New York?
Well, because the way you've read 202 in the past, in this case, well, let me back up before that, because this is about this case, not about the hundreds of thousands of other cases that the Amici would have you address this case on. In this case, the 202 issue was never raised in this way.
It was in his answer. He put it in his answer. He just didn't develop the argument.
Well, it was in his answer. The citation to 202 was there. At that point, it seems, and it's hard to read in the answer, but it seems that the argument was the Connecticut statute should have been applied at that point. But on summary judgment, the only issue, the only argument for the Delaware statute of limitations was the choice of law provision in the agreement. The issue of the borrowing statute was never raised at summary judgment, which is why it was never addressed by the Supreme Court and was never addressed by the appellate division.
Apart from preservation, what saves it? Why shouldn't we apply the Delaware statute?
Because the Delaware statute depends upon a finding of fact that there is some that the claim accrued in Delaware.
If it accrued suppose it accrues at the creditor's residence, and you have there's a document in the record that gives a Delaware address for the creditor. Why isn't it your burden to show that you're somewhere else?
Well, I think it might be if the issue had been raised. And I hate to bring it back to the issue of preservation, but I don't think it's fair to blame the plaintiff for not making a record when the defendant didn't raise the issue that would cause them to make that record. And I don't think there is that record. I don't think there's any record here on which you could find that the Delaware statute should apply. If there are no further questions, I thank you, Your Honors.
Okay, Counselor, thank you. Sir, 1 minute.
Thank you, Your Honor. Judge Siperick is correct. The first page of the answer addressed the issue of standing. It has very much been preserved. Second point, with respect to the 202 not being preserved, I would refer you to pages, okay, here, hold on. Page 12 and 13, summary judgment 29 and 9 and 10. It's hard for me to respond in this quickly, but basically it's there also. Judge Smith, I think, really hit it on the head with respect to that this is an issue of facts, and the facts are here, and they simply do not support with respect to the 6-year statute of limitations. You've got all the statements. The amicus brief filed by the AARP Foundation litigation, I believe, conceivably the New York Bar Association, even addressed a Portfolio Recovery Associates case. So there are some of credit cards, but frankly, merchant accounts have been going back for ages. I've cited many of them.
Okay.
And lastly,
Sir.
this is a constitutional question. We don't treat different people differently. Thank you very much. You guys were really well prepared. I am amazed. I've been in court. It's just
Thank both of you. You are both well prepared.